I thought they were resolved. Senator Espaldon, I believe you had the floor last.
Thank you, Mr. Speaker. Mr. Speaker, before we recessed, we were talking about Bill number 51-34, and there were some concerns raised by our colleagues here about allowing DPW the full discretion to be able to hire somebody above step, to hire a chief engineer above step. And so I would like to proffer an amendment which has been passed out. And also what has happened, what I also did was I passed out the pay grade, the chief engineer pay grade, according to the Competitive Wage Act. And so what this amendment does basically is it allows for the human resources expert to really be a part of this, and really the agency that really has the human resources expertise, as well as the expertise in terms of what the pay grade should be above step, is the Department of Administration. And so when you take a look at this amendment, it basically just introduces the Department of Administration into this piece of legislation, and they will become part of the process, because again, we want them to be able to take a look at who the potential candidates are for chief engineer, take a look at his background or his or her background, the number of years they've had in terms of experience. And so the verbiage for the most part, the first probably 1, 2, 3, 4, 5, 6, 7, 8 lines are basically reflective of what's in the bill right now, with the exception of after the sentence that says after beginning employment, comma, we added a little section that says the position shall be vacated immediately. Let me just read that. If a person filling either position is not a registered professional engineer and fails to attain professional engineer status within a 2-year period after beginning an employment, the position shall be vacated immediately. And again, this is just to make it very clear that if they don't meet the criteria, then, you know, if after 2 years that position has not attained professional engineer status in Guam, then that position will be vacated immediately. And at the very end, the last sentence will be the Department of Administration shall also recommend the step in pay grade S that the selected applicants is entitled to as a result of a review of his education, experience, and professional licensure. So in short, we're just putting this back into the department that it belongs, this whole area, as opposed to just letting DPW have full discretion on what the above step pay grade should be for this position, and DOA would be that agency responsible.
On the Espaldon amendment, Senator St. Nicholas.
Thank you, Mr. Speaker. Mr. Speaker, I understand the amendment. I just have a concern, and that is with respect to the second to the last sentence. If the person filling either position is not a registered professional engineer and fails to attain professional engineer status within the 2-year period after beginning employment, the position shall be vacated immediately. Basically, that language in this amendment is opening the door for somebody to get hired into this slot that is not a bona fide professional engineer. And if you read the title of the bill, it's an act to amend section 6205.2d of Article 2, Chapter 6, Title 4, Guam Code Annotated, relative to authorizing the Department of Public Works to hire a registered professional engineer. And so what I would prefer, Mr. Speaker, is if we're going to be already going down this road of authorizing an above-step recruitment, trying to hire a professional engineer, we really should keep it within the narrow scope of a professional engineer, bona fide. Not somebody who can get hired and give them 2 years, otherwise the position has to be vacated. I've seen on unfortunately too many occasions these kind of doors opening up, and then 2 months away from the 2-year period, someone introduces something to say, extend it, or to strike out the vacated language in the original measure. And then all of a sudden we have somebody that we hired above step who isn't even a professional engineer, which is the whole intent of what we're trying to do with this bill in the first place. So I would prefer, Mr. Speaker, that we amend the amendment to strike that language, starting at the sentence if and ending at immediately. So everything else remains intact, but we take out the part that gives that 2-year window and requires it to be vacated. We're just going to make it a clean bill that says 10 years of experience, professional engineer status.
Senator Ada.
Thank you, Mr. Speaker. Mr. Speaker, that particular provision is provided in there because let's take, for example, the case you may have a young man from Guam who's been practicing. He's a registered engineer in the state of Hawaii. But registered engineers in Hawaii, professional engineers, their registration is not recognized here on Guam. And so while he may be a fully qualified civil engineer in another state and fully credentialed, on Guam, those credentials are not recognized. So they normally then, we would give them 2 years to study up for the Guam registration exam. And 2 years seems like a reasonable time to do that. So I think it would be a mistake to actually delete that provision, and I would object to that proposed amendment.
There's an objection to the St. Nicholas amendment, to the Espadon amendment. Anybody else wish to be heard on Vice Speaker?
Thank you, Mr. Speaker. Yes, I rise in support of this motion, but I'm wondering, in light of the previous speaker, if we could just, I guess the motion is to delete the sentence. Is that correct?
Correct.
Instead of deleting, if the person filling either position is, and then add in the words registered in another state, but, and then continuing with it, but not a registered professional engineer, and then add in the words on Guam, would that suffice? Instead of deleting the entire sentence and, I don't know, accommodating both concerns? I agree that they should be a professional engineer, and I'm not sure, this is not my expertise, engineering, but if you're registered in another state, is that sufficient? Mr. Speaker, I'm offering that as a suggested amendment to the amendment, I guess. It won't work as an amendment to the amendment, so that's just my comment on the amendment. Thank you, Mr. Speaker.
Anybody else wish to be heard on the St. Nicholas amendment? Senator Espadon.
Thank you, Mr. Speaker. The previous speakers raises good points in support of this amendment. However, because of nuances of really what we're trying to do is to ensure that, first of all, they are a professional engineer licensed in Guam or registered in Guam. Perhaps if we could take a real short recess to confer with the mover of the amendment to the amendment to see if the suggestions that were made could then be incorporated into his amendment to the amendment.
All right, maybe a Guam registered.
Yes, but since we cannot make an amendment to the amendment.
All right, we'll take a short recess.
Thank you.
Legislature's back in session. Senator Nicholas, you have the floor.
Thank you, Mr. Speaker. In consultation of the author of the bill and the proffer of the amendment, I'm going to go ahead and withdraw my amendment to the amendment.
Thank you very much. On the main motion, wait, no, we're on the amendment.
Yeah, Mr. Speaker, just a minor amendment. If we take a look at 1, 2, 3, 4, 5, on the 6th line where it reads engineer and fails to attain, is not a registered professional and fails to attain professional engineer status within a 2-year period. I think the and should be changed to an or. And what it is we're looking for an individual who has 10 years of experience, and if the person that is going to fill that position is not already a registered engineer, or, see, it doesn't say registered professional engineer here, but if he may be a registered professional engineer in Hawaii, but he may be willing to come and take the job here on Guam. So we're going to give him 2. Oh, this is getting complicated. Never mind. I withdraw.
Thank you. On the amendment? On the amendment? Any objection? Oh, Vice Speaker?
Thank you, Mr. Speaker. May I then suggest an amendment and move to amend after the words, if the person filling either position is, and add in registered in another state, but, and then after the word professional engineer, add on Guam. You need to write it? So it will read, if the person filling either position is registered in another state but not a registered professional engineer on Guam and fails to attain professional engineer status on Guam within the 2-year period after beginning employment, the position shall be vacated immediately.
Could that be easier stated as a Guam professional registered?
Yeah, oh, yes,
engineer?
you're right. I wanted to do that. Your suggestion is better. If the person filling either position is not a Guam registered, but I want to make sure they're a professional engineer in another state, Mr. Speaker.
It's up on the top. He has to be someplace else.
Okay.
The
Oh, okay,
Department of
then.
Administration has to make sure
You're
he's
right.
a professional engineer somewhere.
Okay, that's perfect then. Yeah, so we'll just add in the words, if the person filling, never mind, then,
It's about the same status that we have with the bar, with attorneys.
right. I'm sorry, Mr. Speaker. May I try that again, Mr. Speaker?
Okay.
Okay, so in the first sentence, 3rd line, engineer for DPW CIP division are registered professional engineers in any U.S. jurisdiction. So I'm adding the words in any U.S. jurisdiction.
All right. That'll be the First Amendment. Any objection to that amendment?
And on the next
I know,
sentence.
but let's take
Sorry,
them
sorry.
separately. Any objection to that in any American jurisdiction? Any objection?
And then in the next sentence, if the person filling either position is not add the word Guam, registered professional engineer,
All right,
And-
on that amendment,
and fails to attain professional engineer status on Guam. So just add the Guam in both situations. So if the person filling either position is not a registered professional engineer, not a Guam registered professional engineer, and fails to attain professional engineer status on Guam within the 2-year period. I think that would then mirror like how we do for attorneys. We allow them who are licensed in other states to practice here for 2 years while they obtain their license here. But they must be licensed. Thank you, Mr. Speaker.
thank you. So the last amendment proffered by the Vice Speaker was professional engineer status on Guam between status and within to insert on Guam within 2 years. Will the clerk read back the entire sentence? The entire, with all of her amendments now.
If the person filing either position is not a Guam registered professional engineer and fails to obtain professional engineer status on Guam within the 2-year period after beginning employment, the position shall be vacated immediately.
Okay? Is everybody happy with that? And on that, anybody wish to speak? Thank you. Now the entire Espaldon amendment with the amendments made by the Vice Speaker. Any comments? Anybody wish to speak on it? None. Amendments accepted. On the main motion. On the main motion of Bill 51-34. Anyone wish to be heard? Senator Espaldon.
Just real briefly, Mr. Speaker, DPW is in great need of a chief engineer, and I think this legislation definitely would help them accomplish acquiring one or two of them. But I fully support this legislation. Thank you, Mr. Speaker.
Thank you very much. On the main motion, anybody else? If not, the sponsor is invited to close.
Thank you, Mr. Speaker. Mr. Speaker, just one amendment that I think on page 2, line 19, it reads, the Department of Public Works is authorized to recruit and compensate above step 10 one professional engineer. And in the previous amendment that was introduced by the senator from Tamuning, he provided a table of the chief engineer pay grade S, and basically the previous amendment that we just passed got the Department of Administration involved, and we'll take a look at the credentials of the individual, and then would basically pay them according to their experience level. So in the bill, it calls for a minimum experience of 10 years. So if but we want to hire above step 10, which means then we want to hire somebody at step 11, 12, 13, or 16. Well, it's just inconsistent. So I think because if then an individual with, let's say, 10 years of experience applies, meets that qualification, according to this pay table, his compensation really should be at the step 9 level. But we're saying you can hire above step 10. So I think the way to resolve the inconsistency is that on line 19, page 2, we simply read, recruit and compensate above step, and delete the numeral 10. And what that does is, because right now Guam law limits, you can only, if an individual comes in and he applies, and he comes with even 16 years of experience, he can only be hired at the step 7 level. Anything beyond that is going to require an act of this legislature. So I think if we just say above step, then that kind of brings some consistency to the bill. And we would need to make, section 2 is where we would need to make that change. And that's the only other change. The only other, where that's mentioned above step 10 is in the legislative findings on page 2, line 12, but findings and intent really don't carry force and effect, so I'm not even going to go in there. It's just the section 2, line 19, that we should make that amendment.
So, Senator Camacho Torres and then Vice Speaker.
If I may just bring up a point of clarification. A few lines up from line 19, page 2, under section 2, there is also reference to the position of chief engineer, and I wonder if it's also prudent at this point to eliminate reference to step 10 specifically, so that it also, this law, in its attempt to recruit people at a higher pay, also, without looking at the chief engineer's pay grade, I wonder if it's also prudent to address any references to step 10 that are in line with the chief engineer position. We've inserted the CIP division, but in terms of the chief engineer, is that an issue? If the sponsor may yield, or is it not necessary to?
Well, no, it probably should, because that's where you have another grade 10. I mean, step 10.
Because then the greater of the consideration is given to the CIP, the new CIP, as opposed to the chief engineer who's bound to. Well, I don't know. I just wonder if we have, without looking at a pay grade schedule for the. Oh, I take that back. This is the chief engineer pay grade schedule.
Yes.
Okay. Now that was my confusion, Mr. Speaker. So I withdraw my comments. Thank you.
Thank you.
Maybe we should just move to delete section 1. That's the only other place where you would find above step 10 mentioned. So instead of, so we can, I'll move to delete section 1, the findings and intent, has no
All right.
force and effect.
All right.
Point of order, Mr. Speaker. Before we can entertain that amendment, I think we need to dispose of the previous amendment, which was just to delete the number 10 on line number 19.
All right.
Okay.
Withdraw. Go back. Madam Vice Speaker, did you had a comment? Which amendment? Okay. He's going to withdraw it. No. He's withdrawing his amendment to line 19 first. Are you withdrawing your amendment to line 19?
No.
For right now, because you can't have two amendments on the floor at the same
Okay,
time.
I'm sorry. I thought we already took care of that amendment. So the amendment that's in play then should be line 19, which deletes the number 10.
Yes, but Senator Espaldon has brought up the point that you can't delete section 1 until you finish with
Understand.
the amendment with
My
19.
mistake.
So will you withdraw 19, delete 1, and then go back to 19?
Oh, okay, fine.
All right, we've withdrawn the amendment to 19. We're going back. Your amendment to delete section 1.
Yes, we'll just move to delete section 1 in its entirety.
Your next amendment.
Okay, the next amendment is page 2, line 19. Remove the number 10, 10, so that it reads recruit and compensate above step. It is authorized to recruit and compensate above step
Okay.
1 professional engineer.
On that amendment, I believe the Vice Speaker wishes to speak, and then Senator Esteves.
Thank you, Mr. Speaker. It's just really a point of inquiry. I have no objection to the amendment, but I want to make sure that removing the number 10, which is an existing law that they use to hire the chief engineer for the highway division, does not affect that hire. That's already, the law was in.
So, as a point of information, Mr. Speaker, there currently is no chief engineer occupying the highway division position.
Okay, then. All right, then. Sounds good. And no objection to the amendment. Thank you, Mr.
Senator Esteves.
I'd like to add that we change section 2. In removing section 1, that section 2 then becomes section 1.
Okay. We'll do that. On the amendment to strike the number 10 on line 19, any other senator wish to be heard? Any objection to that amendment? Legal counsel will renumber appropriately. On the bill as amended, you may conclude.
Thank you, Mr. Speaker. Mr. Speaker, I certainly, of course, urge my colleagues to favorably consider Bill 51-34 as amended, and also to authorize the legal counsel to make any technical corrections, such as in the title and possibly on line 19, the grammar, if a comma is needed or whatever. Other than that, I urge my colleagues to vote favorably on the bill. Thank you very much.
On the motion to place Bill 51 in the voting file, any objection? Bill 52, Senator Addo.
Bill 52, Mr. Speaker, first of all, I don't have any graphics to pass out. It's all in the committee report that's online. But what Bill 52 does is it grants administrative jurisdiction to the mayor of Jigo to be a plot of land that's about 5 acres in size. At the request of the mayor, he was asking for some property to be able to develop for a recreational area. So all of you who are familiar with Jigo, the only recreation area really that they have up there is the baseball field that's right there in the middle of the village. And so up further north, across from the UP Elementary, is a large Chamorro Land Trust tract of land. And the Chamorro Land Trust had earlier master planned that area with subdivisions along the boundaries and a large open space in the center of it, which is intended for recreational facilities. They can build, there's certainly enough property there to build a baseball field, a walking track, and so the mayor has asked for administrative jurisdiction of that property, which is Lot 9, Block 7, Tract 9210. This is nothing new. We did the same thing last year in Arahan for the mayor there. And by doing this, by giving them this grant of jurisdiction by law, they are then able to get with GURA and be able to apply for grants to then begin developing that area. Now, this grant of jurisdiction to that plot of land actually is to substitute for another tract, which we got two bills that follows right after this, where he originally had jurisdiction, administrative jurisdiction, but really the particular site can be better utilized for housing under the Chamorro Land Trust program. So instead what we're doing is we're by law transferring administrative jurisdiction to the Jigo mayor. The Chamorro Land Trust Commission certainly has had an opportunity to review this, and they have, through a resolution, given their nod of approval to this grant of jurisdiction to the mayor to Chamorro Land Trust property. So I ask my colleagues to favorably consider this bill.
On Bill 52, any senator wish to be heard? On the main motions, Senator Tommy Morrison. Did I see your hand go up? Anybody else?
Thank you, Mr. Speaker. I rise in support of Bill 52. I just want to point out that the author is correct. In the previous, I believe in previous legislature, at least with the 32nd and 33rd, we moved forward with certain facilities throughout our government that were under different jurisdictions. The Department of Education, the Department of Parks and Recreation, and we transferred those controls under the mayors. I appreciate this effort because I think this is something that we should continue to build upon. And looking at the mayor's inventory, what they control, and actually what they're maintaining, it makes sense to move the authority under the mayors, and for this purpose, to expand in recreation facilities and other programs they may want to be do in their communities. So I appreciate the efforts being made here, and I look forward to working with the author, because I too would look forward to transferring more control to the mayors. I think that's what we should be doing now, and I think we're setting the tone here and with Bill 52. So I look forward to more measures. Thank you.
Thank you very much. Madam Vice Speaker, did I see your hand go up?
Thank you, Mr. Speaker. I support the Jigo mayors and the community of Jigo's need for recreational facilities and their efforts to develop these facilities. My issue is that this property is held in trust. The property that's subject of this bill is held in trust by the Chamorro Land Trust Commission. It was intended to be held in that trust in perpetuity. And removal from the land trusts, I just don't believe that's necessarily the answer for these types of facilities. In their foresight, the author of the Chamorro Land Trust bill years and years ago, they designed it so that the Chamorro Land Trust was going to include that they had the ability to license lands within the communities where they were giving out residential leases and agricultural leases, that the Chamorro Land Trust was authorized to give licenses for public purposes, such as parks, recreational facilities, churches even, They list schools. And so these public purposes, I'm looking forward to the Chamorro Land Trust using that authority that they have to give these licenses, but to hold title to the land, because that is what the trust was intended to do. But I appreciate the author's ability to find land that was outside of the Chamorro Land Trust inventory and I guess compensate the Chamorro Land Trust in exchanges, to create an exchange. Sometimes I know that, and it was cited in the Inarahan example, that we transferred title to this land, and we're using here the word administrative authority or jurisdiction, but we transferred title because these new entities want to use that land and borrow against it to build buildings or infrastructure, things like that. And so I understand when title needs to be exchanged, but in this situation, there is not today any existing plan to build a building, but we're going to build recreational facilities. I don't know if transfer of title is really necessary, or if this is just something that, and I'm hoping that all the village mayors who have Chamorro Land Trust land in their villages are able to come into working arrangements with the Chamorro Land Trust for licenses of these properties that are best used for recreational areas, especially where they will serve, as in this case, Chamorro Land Trust leases. There's leases in this area, according to the testimony, of residential leases, and so it's a perfect match as was intended by the trust when it was set up. And so I just wanted to state that concern on the record, and that I don't know if transfer is necessary at this point, and if we can, create a new way of doing things where the Chamorro Land Trust holds its title to the property, holds it in trust, is able to use the value of that property and what it needs to do, and yet allow the communities where these lands are located to also get licenses to use this land for public purposes. And so I just wanted to put that on the record, Mr. Speaker, but I do very much appreciate this bill's efforts to give the recreational facilities that JIGO needs, and I absolutely support that, and that we were able to find other land to exchange. I think they passed out 2 amendments that I would like to proffer, Mr. Speaker. Is there only one?
They've been circulated.
Okay,
Please.
so the first amendment is to add a new subsection C, which would say, no quarrying or mineral extraction shall take place on Lot 9, Block 7, Tract 9210, without approval by the CLTC and the Legislature in Guahan. This mirrors the current restriction against quarrying or mineral extraction for commercial leases, and so I would like to add that amendment, Mr. Speaker.
On the first amendment proffered by Vice Speaker Tulahi, anyone wish to speak? On the mineral extraction amendment proffered, anyone wish to speak? Any objection? Oh, go ahead, Senator Nelson.
Thank you, Mr. Speaker. I just want to support this amendment. It has been general practice where at times the government lands are used or given to another agency, and many times we look the other way while they start to quarry our lands and start to make money off of it, but that money does not go back into the government. So I just want to state for the record that I support this amendment.
Thank you, Senator Lee.
Thank you, Mr. Speaker. I also rise in support of this amendment. I think it's imperative that the members of this body continue to act in a way that protects our island and our resources. So I thank the Vice Speaker for offering this amendment, and again, I stand in support. Susan Mossy.
On the amendment, any other senator wish to be heard? Any objection? Senator Espaldon.
No objection, Mr. Speaker, just a technical amendment on this amendment form. We have line 3 of page 2. This is a one-page bill, and just wanted to note that perhaps legal counsel can make that technical change. Thank you.
Thank you. There being no objection, the First Amendment. Your Second Amendment, Madam Vice Speaker.
Yep. Mr. Speaker, my bill has 2 pages, so I just want to make sure now we're all looking at the same bill. This is the original version of the bill, the back. Has a section 3 also.
No.
Okay. No, I'm not. I'm not looking at. No. Sorry. Okay. So. All right. Then, no objection to that, Mr. Speaker.
Okay.
Mine was. Should I proceed, Mr.
Please.
Speaker? Okay. Thank you. Thanks, and thank you to my colleagues. And so I would like to make a second amendment. This is to amend subsection B of section 1. And so this will be in line 10 of the bill, to just add in the words. Now, the Jigo mayor is a good friend of mine, so this is not anything personal to him, but I would like to make this kind of standard for all these land transfers that we're putting a lot of faith in the transferees to develop these things for their communities. And so I just want to add in the words, if the property is not developed to a functioning recreation and park area within 10 years, and then I want to add in, or if there is a violation of land use regulations, permits, or conditions, and then continue with the existing administrative jurisdiction shall expire and the property shall revert to the land trust. So to add in a requirement that they not violate any of the building code regulations and things like that.
On the Tulahi amendment to add those 14 words, Senator Torres, then Senator Estevez. And then Senator Narstein.
Thank you, Mr. Speaker. I applaud the mover of this amendment because I think that this amendment gives us at least a little bit of assurance that the intent of transferring the lands from limited Chamorro Land Trust inventories to the jurisdiction of the municipality of Jigo is done with all good intentions and with all good results. And I too, in the mover of this amendment, in her previous remarks, talked about how the timing is somewhat questionable. You would give something ahead of the plan, ahead of any concrete assurances that the intention of the land transfer is actually going to be realized or will materialize to the best interest of the community. I at first would not have been in favor of giving over a tract of property without a sound plan, without any demonstration that there is something in the works, that there is an anticipated funding source to have it actually materialize. But short of that, understanding the needs of a community, I believe that this amendment at least gives us some assurance that if the land is not going to be developed as contemplated by this bill, that there is a reversionary clause, and a reversionary clause with more teeth than just saying if you don't develop it into a recreational park area within 10 years, then it reverts back. This actually says if you do not conduct yourselves in a manner contemplated by law, by doing other than developing a park and recreational area, then it'll revert back. And I believe that that is the teeth that's needed, short of a plan, short of anything concrete, that can give us the assurance that, in this case, it's okay to give away Chamorro Land Trust lands, given the fact that we've got a list of applicants that may never, ever get entertained, which is quite detrimental to their hopes of ever owning property or having homestead of their own. So I rise in full support of this amendment. The only thing that I would question is whether it is necessary to have some sort of a reporting mechanism or we can just trust that the Chamorro Land Trust will do its due diligence in monitoring the progress of the development over the course of the next 10 years. I don't have an amendment to that effect, but I suppose that we can just ride on good faith that the Chamorro Land Trust will in fact adhere to the law and this amendment, should it pass, by monitoring and assuring that the land is in no way misused or that the municipality of Jigo doesn't move forward in the absolute development of just a recreation area for the community. Si Zeus Maasi.
Thank you very much, Senator Torres. Senator Estevez, Senator Snoggerstein, and Senator Nelson.
Thank you, Mr. Speaker. The intent of the amendment, I do rise in support of that, but as a point of information, I just want to ensure that we're careful when we look at this automatic reversion. On Guam exists the cradle-to-grave law. In terms of environmental sense, it revolves around liability. So if we extend this with an automatic reversion clause, for example, and again, full trust and faith in the municipality of Jigo and its mayor, but just within the language. And if we're looking at applying this language to other transfers, we should be very careful. For example, if there is a violation, per se, for environmental aspect, either hazardous or non-hazardous, when it comes to liability, whether it's from the local environmental protection agency or the federal environmental protection agency, that liability will automatically fall on Chamorro Land Trust and Gov Guam. And now just having a little foresight of the difficulty that we would have to front that and then seek punitive damages and fight that with whoever owned it before because of the liability laws of property ownership. So that might be something, I don't have a solution right now. I do support this amendment, but that might be something I would like to confer with legal counsel and just ensure that maybe there's some language that we can add, maybe giving us the ability to pull the land back, but not to automatically do that and potentially put ourselves in a difficult position in a worst case scenario situation. Thank you, Mr. Speaker.
Thank you, Senator Estevez. Senator Snoggerstein.
Mr. Speaker, I rise in support of the bill and the amendments. The only thing I question, because I am from Jigo, is the time period, 10 years. How long is it going to take Chamorro Land Trust folks to issue those leases? Have all the lease been issued? Because there's a lot of people in Jigo that don't have the lease yet and the ability to build in that area. So in 10 years, and a little bit of correction for Senator Ada, there's 2 areas in Jigo that has a recreation, and one of them is in Agafagumas. There's a skate park up there. And this being on the back road of Jigo, this is great. But I'm only concerned that in 10 years, if there's no true development of Chamorro Land Trust, this will revert back to the Chamorro Land Trust program, and they'll never build a park. So that's what I'm concerned about, the 10-year lease of reversing.
Mr. Speaker, with all due respect to my colleague right now, we are on a certain amendment that is being made to the bill, and it basically focuses in on the violation of land use regulations, permits, and conditions only right now. Once we dispose of this, then I believe that our esteemed colleagues' remarks probably would be more well placed.
Okay, thank you. Senator Nelson. Okay. Anybody else wish to speak on the Terlahi Amendment? Okay. Well, we're in recess. back. Legislature's back in session. Senator Esteves.
Thank you, Mr. Speaker. I'd like to proffer an amendment to the amendment. At the end of the amendment, I'd like to add, upon resolution adopted by the Chamorro Land Trust Commission.
Does everybody get that? Upon resolution adopted by the Chamorro Land Trust Commission. Senator Nicholas.
Just point of clarification, Mr. Speaker. So this is with respect to the amendment that's going to create the provisions for the land to revert back to land trust?
Correct.
Well, if we add that provision and the land trust does not adopt a resolution, then that means that the property will never revert back absent the resolution?
It would seem to me that, well, depending on whether or not it was even given away, it may make, if they don't want it back, they're not going to ask for it back.
Mr. Speaker, there's still the or clause, so it's either 10 years of non-development or the violation. The clause on item B, if the property is not developed, already exists in the bill. This is an amendment to the addition, so to the other stipulation.
If that is the intent, Mr. Speaker, I would advise that we put a period. I would advise that we separate the two sentences because it implies that the resolution is necessary for both actions to take place. And my only concern about that amendment that's being proffered is my initial understanding is that this section B was intending to keep everything automatic. Now we're going to be depending on the land trust having a proper system in place to be able to remind them that they need to exercise a resolution to pull this property back. And 10 years is a long time for board members to change, legislatures to change, and awareness to change, that kind of action will be necessary for the reversion versus it just being automatic for the land trust. So
I think the concern goes back to the liability, and if it has been used as a dump for the last 5 years and has all this toxic waste on it, if the land trust wants it back at that point, because I think there was concern about liability. Why would the Chamorro Land Trust take on that liability in the event that?
But I think
at least that was his concern earlier.
No, I understand that. I think the original language, though, about violation of land use regulations and permits, I think that original language being an automatic condition would actually protect the property even more versus land trusts not monitoring it, going out and testing it or whatever, and not being informed that they need to exercise this resolution, and then it never happens. Versus if any of those things were to occur, it would automatically happen.
Madam Vice Speaker, do you have a resolution, I pray tell?
During the recess, it was brought up that regardless of all of this, they would still have to find cause. So if there was a violation of the land use regulations, permits, or conditions, there's still an administrative process to identify the cause. And at that point, then it would be incumbent upon Chamorro Land Trust to execute its responsibility to pull it back. But to address the concern was the automatic reversion. Because of other existing laws in environmental law, which is cradle to grave, the liability falls onto the property owner. So, for example, if the property were to be fined by, say, Guam EPA, US EPA, Guam Fire Department for a violation, and that becomes the cause of the automatic reversion, the liability would then be placed on the government of Guam and Chamorro Land Trust. And I'm just trying to prevent the possibility of this happening and then us having to fork over and front the cash and become liable and then have to go back through the courts in order to receive damages or to get reimbursement and to avoid all the costs of potential legal fights, battles, bankruptcies. So if the CLTC had the ability to do it via resolution, they can maintain the liability on those that are responsible until the cleanup is complete. And when you're talking about agencies, whether it's the federal government or local government, then those are both not just punitive damages, but potentially criminal damages that they can go after them directly for as the one who caused the issue, so that who's liable. So again, I'm just trying to be careful and plan for the future.
All right, on the Estevez amendment, I understand Senator Nicholas' concern. We'll deal with that after we adopt the Estevez amendment and, if necessary, put in the period. But we need to, Madam Vice Speaker.
Thank you, Mr. Speaker. On the Estevez amendment, this language in this bill is not to the perfect legal language, perhaps, that they would put in an actual lease. I mean, that might go on for pages and pages, but I think for our purposes, I'm hoping it's sufficient, and that, yes, I mean, I understand the previous speaker's concern that it puts even this automatic reversion for not developing the recreation area, it puts that subject to this CLTC resolution. But I don't see that to be such a problem. Automatic reversion is very strong and it looks nice and clean, but really somebody is going to have to make a determination that it's not a functioning recreation or park area. And just in doing this exercise, I realized, yeah, what if the mayors for some reason get delayed and we're up to year 9 and they finally are, on a roll, and we've got a deadline year 10, and it just gives a little bit of flexibility. And in this case, in this scenario, it's going to be Chamorro Trust who needs to do their diligence, and we're just going to have to hope that they do, because it's in their best interest. It's in their inventory, and maybe we are going to just have to do our diligence to remind them when they get new leadership, we're still alive. But it's just that somebody is going to have to make that decision, and this gives a little bit of flexibility where we might need it. I mean, I'm hoping it doesn't allow for abuse, but I think for our purposes today, this should suffice. So I support the amendment. Thank you, Mr. Speaker.
All right, anybody else on the Estevez amendment? Any objection to the Estevez amendment? On whether or not there's a need to separate them or to distinguish its application? Did anybody want to take that up? Senator Nicholas? Or were you happy with the explanation proffered by the Vice Speaker?
Thank you, Mr. Speaker. I guess, this is one of those circumstances where we can see how it turns out. I would prefer that if the intent for a reversionary provision is to allow for something to automatically happen, if something else doesn't happen before that should all be automatically put into place, and it should be a trigger. Now we're requiring the land trust to not only give up the property, but actively seek it back. And my concern is that going forward, if this becomes a practice, we can see circumstances where now the releasing of lands, though that's required by the legislative body, will become permanized by inaction on behalf of the land trust. And so, for example, if we were to authorize a commercial lease and someone were to put a provision in there that says that it would require a resolution from the CLTC to recover that upon expiration or violation of that lease, all of a sudden the CLTC board will be able to, on their own, release commercial lessees from having to meet the original provisions of their mandate because they're not exercising the reversionary duty of actually introducing and passing their own resolution. So my thoughts are that if it is the intent of this body to protect the land trust in a way where if we're going to be granting exceptions, if those exceptions are not, if the parameters of those exceptions are not met, then automatically it goes back. If we're now saying if the parameters of those exceptions are not met, then the land trust needs to do something in order to get it back, we are basically releasing that land to the entire jurisdiction of the Land Trust Board with respect to recovery. And, Mr. Speaker, those appointees are appointed by the governor, and it is quite possible that in future circumstances, if this becomes the norm, then leases could be given out, exceptions could be made, and then those exceptions could not be followed through with. And that's just a concern that I have by making this become an operation in this legislation, that it opens the door for more of the same. Thank you, Mr. Speaker.
Thank you. Senator Estevez?
I would just like the record to reflect, I do understand the concerns, but as previously stated, there is a drastic difference. They're two completely separate things. What is being done here with the transference of administrative jurisdiction to a municipality versus a Chamorro Land Trust lease. As the good senator from Zotnya had mentioned, within a lease, we're talking pages and pages of documents that are much more detailed and specific as to what is okay and what is not. With regards to this and the transference to another government entity as opposed to a lease, in terms of administrative jurisdiction to the municipality, this is a very, very general action that we're doing via the legislature. So again, for the record, leases are done by Chamorro Land Trust. And when they do those, they are very, very detailed and should cover all of the bases, completely unrelated to what we're doing here. But I don't expect this to be the norm for everything going on with Chamorro Land Trust. I just want to be clear, it's just for this specific bill and this type of action. Thank you.
Thank you very much. Senator Nelson.
Thank you, Mr. Speaker. I just have an inquiry for Senator Steves for his amendment. Can you state specifically what is your amendment, the Chamorro Land Trust resolution?
The clerk will read it to you.
I'm sorry, Mr. Speaker.
Will you read the amendment?
Can the clerk please read the amendment?
Upon resolution adopted by the CTLC, Chamorro Land Trust Commission.
So the question is the Chamorro Land Trust has to write a resolution upon the 10-year expiration if they do not meet the requirement?
As it's currently amended, that is the way it's written. But again, that was mainly for a focus of violations of land use. To the question as to whether or not we can separate it, I have no problem with that. I have no problem with the 10 years still being an automatic reversion. That was not the intent of the amendment. But it has been brought up that it may be something to think about, that they have the flexibility. Again, to further clarify, the whole reason for this is because, I may be wrong, but it's to my understanding that apologize, Mr. Speaker, in order for a jurisdiction to apply for the grants in order to build these facilities, they can only apply and be granted these grants if they have control of the property. So, that being said, it's important that we allow them to have this property and be able to develop it if they want, because that's the only way to make the property available to them. And that's the difference between the transference of administrative jurisdiction versus a lease. If they were able to get the grants via lease, then Chamorro Land Trust could just lease it.
Mr. Speaker,
Address the chair.
yes, Mr. Speaker, I object to this amendment. I think
It's been adopted.
Oh. Well, for the record, I'd like to say I object to this amendment, and I believe it complicates things more than it really does.
Thank you.
Thank you.
I asked twice. Okay. Oh, yes.
Mr. Speaker, may I speak one more time? I know it's notwithstanding the rules. I would like to offer a suggestion that I think will appease most of the people, to leave the original B as is and take my language and put it into a new subsection D, so that B will be as is. It says if it's not developed in the recreation or park area within 10 years, administrative jurisdiction shall expire and property shall revert. That stays as is. So just take my floor amendment and strike out everything until you get the words, if there is violation of land use. So I would move this to be a new D, Mr. Speaker. If there's a violation of land use regulations, permits, or conditions, administrative jurisdiction shall expire and the property shall revert to the Chamorro Land Trust inventory upon resolution adopted by the CLTC.
Thank you.
Thank you.
The amendment has been amended to make it D, because she already added a C. Okay? So the amendment as amended, any objection? Oh, God, James. Go ahead.
It was just a matter of clarification. We passed several amendments to the amendment and went down this road. So after all those amendments have been basically not objected to and were passed, now we're back to the original amendment as amended, and we're amending this now, right? And the new amendment...
We're splitting it because there was a suggestion by Senator Nicholas to have a period.
Yes.
The Vice Speaker has done one more. Rather than just a period, make it a whole new section.
Just make it a whole new section.
So there's absolutely no question that the resolution does not apply to the 10-year. It only applies to this.
Right, and which is what the good colleague who proffered that amendment to add the upon resolution adopted by CLTC said he had no objection to. So I just wanted to clarify, Mr. Speaker, that that's exactly what happened. Thank you.
Yes. Did I clear all the amendments now? All right, yes. On the main motion, any other amendments on the main motion? If not, the sponsor is invited to close. Senator Ada, you may close.
Thank you, Mr. Speaker. I certainly appreciate the good input that has been provided by many of my colleagues. And I think certainly one of the concerns that was raised was that at the public hearing, It was indicated, at least by the mayor of Jigo, who had requested for a tract of land to be able to develop for recreational facilities in Jigo. And so in response to that request, this property was identified, which actually was originally a part of the Chamorro Land Trust master plan to be used as a recreational area, and is situated in the center of a larger tract of land of residential Chamorro Land Trust land. And so this piece of property is certainly very well situated for that purpose. And because there was no plans that, that's in existence right now, other than this, really a grand idea that we want to, pursue some grants to be able to develop the area for recreational facilities. It's kind of a chicken or the egg question first. If, do we go pursue the grants and then find out later that maybe the property is not available? Or do we pursue and get that land locked in and then go and pursue the grants and begin developing the plans for that recreational area? The second thing that was, and so at any rate, because of the fact that another similar area had been set aside for the same purpose for the municipality, and 24 years lapsed and nothing had happened, I think that the inclusion of that reversionary clause certainly is very appropriate to say, the clock is ticking, and either we do something with it, and if not, then let's make it available for whatever other requirements may be in place at that time. And finally, there was the question about, these are properties that were set aside for the Chamorro Land Trust. And the fact of the matter is that this is property that is being put under the jurisdiction of the Jigo mayor, that will benefit the prospective lessees of Chamorro Land Trust properties that surrounds this few acres of land, and so it will benefit that community, that part of the community, but it will also benefit other members of our community, whether they are eligible for Chamorro Land Trust or not. It will benefit them because there will be an additional area that will be available for recreational facilities. So I think this is important, and we'll find that in the next two bills that follows, we're actually, this jurisdiction is actually a replacement for jurisdiction that was given 20 years ago, of which nothing happened. And so now we're taking away the next two bills, takes away those jurisdiction and gives the property back to the Chamorro Land Trust so that they can put it to better use for residential properties. And we'll discuss it more when that bill comes up. Mr. Speaker, I'd like to move to place Senator Therese Terlahi as a co-sponsor on the bill.
Any objection?
And with that, I ask my colleagues to favorably consider Bill 52-34. Thank you very much.
On the motion to place Bill 52-34 in the voting file, there being no objections, so ordered. Bill 53-34.
Thank you, Mr. Speaker. Mr. Speaker, the Bill 53-34 LS is a bill that Lot 7116-1-2-1 in the municipality of Jigo. We're talking about a piece of property here along the back road to Anderson, Route 15. And all the bill does is it takes away, it deletes, it rescinds the administrative jurisdiction that was given to the mayor of the municipality in Jigo, rescinding the administrative jurisdiction that was given to him to that property for the purpose of developing a mini park and the relocation of the Army Memorial and whatnot. And so that's all it really does. We rescind the administrative jurisdiction. We're returning that piece of property, in this case 3 acres, back into the Chamorro Land Trust inventory. Now what that does is it makes that 3 acres available to be leased out to Chamorro Land Trust applicants. And this particular piece of property is, you know, ideal. There's really no reason why by the next month that leases couldn't be given out for these properties for Chamorro Land Trust applicants. It has access to it. There's water and power available to the area. So the better use for it right now is to lease it out to Chamorro Land Trust applicants. And so that's what this does. And so, you know, again, because the law requires that you can only have one land transaction per bill, there's this bill and then there's another bill right after this that are really companion bills. What I want to point out is the fact that, you know, we're talking about 3 acres here, a half acre there. It's kind of like, you know, a drop in the bucket, right? But it's not a drop in the bucket for the certain individuals that live on that are already on that property. A good example, there's an individual, he's a veteran, and he was on that property because by default, basically, he was originally in the Arrendo program, and then when the Chamorro Land Trust program came into being, basically gave him the rights to be there on a 1/4 acre piece of property. And so he went and he applied for a VA loan, and lo and behold, found out, sorry sir, first of all, you cannot get a lease to build a house on a 1/4 acre lot because there's no sewer in that area. You need a minimum of a 1/2 acre, or an acre, I believe it is. But at any rate, the acre that he was on certainly would not allow him to build a house on it that was not serviced by a sewer line. Then on top of that, the property, so the Chamorro Land Trust was willing to give him additional land to be able to build that house properly according to Guam code. And find out that you can't, because the property right next to it does not belong to Chamorro Land Trust. It's under it was never put into the Chamorro Land Trust, and it's under the administrative jurisdiction of the Jigo mayor. Long story short, by then rescinding the administrative jurisdiction on this piece of property and give it to the Chamorro Land Trust can then do the necessary surveying and make the properties whole so that people can actually utilize it to build for their families. And a very good case is this one veteran that was able to go out. He's got a job. He was able to go out and get a VA loan. But guess what? Sorry, we can't expand into that because that's not Chamorro Land Trust property. It's under the administrative. So what this bill does is it's going to clear all that. And let's do right by this individual and the other individuals that could possibly get leases for that. So it's a simple, 2-page bill. We rescind the administrative jurisdiction that was given 24 years ago, put that property back in the Chamorro Land Trust. Chamorro Land Trust can now do what it needs to do to make those lots available. So I ask my colleagues to favorably consider this bill. Thank you.
On Bill 53-34 on the main motion, any senator wish to be heard? Senator Nicholas. After Senator Nicholas, anybody else? Senator Nelson, go ahead.
Thank you, Mr. Speaker. I just need to rise to a point of order with respect to this particular bill, and there are a few other bills I'll be rising the same point of order for. When this bill was filed with the Committee on Rules and it was processed, we had to process it as a Section 2107B 2 GCA filing. And what that basically means is we're indicating in our Committee on Rules processes that this bill has a certain provision in public law that it needs to comply with, namely Section 2107B of Title II Guam Code Annotated, which reads, quote, "No such bill authorizing the transfer of land or leasing of land may be considered by the legislature on third reading unless accompanied by two appraisals on all land concerned, appraised for highest and best use regardless of zoning, from two separate licensed real estate appraisers, one of which appraisals is not to be more than 12 months old, and which appraisals are paid for by the transferee." And the reason why it's important for me to raise this, Mr. Speaker, is because there's very few laws we have on the books that govern procedure. One of them is a law that requires a public hearing on a bill before it can be brought to the floor. This Section 2107B Title II is another law governing procedure. And it speaks specifically to a bill going into the third reading file, and that if it authorizes the transfer of land or leasing of land, it requires two appraisals. Now, I've had some conversations with legal counsel, and perhaps it can elaborate further, but part of the conversations that we've had was if you include a notwithstanding any other provision of law into the bill, would that allow us to be able to move it to third reading? But my concern is that that notwithstanding provision becomes effective upon passage of the bill, not upon procedural motion of the bill. So I'm unsure at this juncture, and I want to raise this as an official point of order, because in our Committee on Rules processing right now, Mr. Speaker, we're thorough almost to a fault in terms of how we make sure things move forward. And when this bill was asked to be placed onto the session agenda, we had to specifically do so subject to this section in the law. This section doesn't prevent me as Rules Chair from putting it on the agenda, but it does specifically prevent it from moving to third reading. So in light of that, I yield to you, since we are in session, to at this juncture provide the guidance necessary for us to be able to determine how to properly address that requirement in public law, and whether or not we can move this bill to third reading without the two appraisals that are required in the statute. Thank you, Mr. Speaker.
Thank you very much. In light of the relationship of 51, 52 and 53, and 67, I'll rule that the notwithstanding provision waiving the appraisals waives the appraisal requirement.
Just a point of order on the ruling, Mr. Speaker. Two things. First is there is no, in Bill 53, there is no notwithstanding Section 2107B language in the actual legislation. So that would need to be added as an official amendment. And secondly, you've referenced Bill 53 and Bill 67. Both of those, they are correlated. They both have the same problem. And the reason why I'm raising this point of order, Mr. Speaker, is because the whole intent of that law is just to ensure that when there's transfers of land taking place, the entire body and the public is aware of the actual valuation of the exchange. And it's not just, a parcel for a parcel, and we're unsure of exactly what the values are that is one person winning, is one person losing, how much is a plus, how much is a minus to the various parties involved. So I'm not quite sure if this is, I pose the point of order as a question. I'm not sure if it is something that can necessarily be a ruling because it's statute. But I'm in a very different kind of territory right now, Mr. Speaker, because we are in session, and I do want to yield to you as a presiding officer.
We'll take a short recess. on. We're back on the record. Senator Adams.
Thank you, Mr. Speaker. I'd like to make an amendment to Bill 53-34. And that amendment is on page 1, line 4, to insert the phrase, notwithstanding any other provision of law, rule, and then will follow, and notwithstanding Department of Land Management, da-da-da-da. So that would be my amendment.
Okay. So is it clear that on line 4, they'll be inserting notwithstanding any rule, regulation?
Any other provision of law, rule, or regulation.
Any
comma.
objection? Senator Nelson and Senator Nicholas? Senator Nelson.
Thank you, Mr. Speaker. I just have a concern, and yes, I'm objected to do that, the notwithstanding, because essentially this is a new legislature, and this session is the first time we are hearing land bills up on the session agenda, and I believe that, our island is so small. We continue to give out these leases for our Chamorro lands, and we don't reap anything back from it. And so if we exclude this section, essentially we're authorized to give them the property with no plan, with no appraisal, and I don't think that's a right practice. I don't like to, we would set a new precedence again to continue the land dealings the way we've been doing land dealings in the past. And I hope my colleagues...
We're on Bill 53. We're taking land from from land management and giving it back to Chamorro Land Trust.
Okay. I thought we were talking about the bill that we were just...
That went down to voting file already.
I thought we were going to bring it back out from the third reading.
Not that I know of.
Because of the point of order that Senator Nicholas brought up.
No, the point of order is to this bill.
Okay. But it... Okay.
Just a point of order, Mr. Speaker, just to help clarify. We have two bills. Bill 53 is transferring from land management back to land trust. Bill 67 is transferring from land trust back to land management. And I don't need to speak for the author, but it is my understanding that this is a reversal of a previous authorization for both parcels years ago. The reason why we're in a situation right now where we're having discussion about Bill 53 and it has to contextualize into Bill 67 is because, well, one of the reasons why it's two separate bills is because of statute. Statute requires a single measure for every single land transaction. The question before the body now, with respect to the amendment that's being proffered by the author, is also a question of statute. Can a notwithstanding provision bypass a statutory requirement that an appraisal be done on properties when there's a transfer or a lease taking place? I don't know if that question has been exhausted, but I can understand the concern that's being raised by the retiring speaker. The intent of the statute, from my understanding, and I don't mean to interpret it for everybody, but from my understanding is we just don't want land to be transferred or leased without understanding what kind of values we're dealing with. And I totally get the intent of Bill 53 and Bill 67 and the intent of the author, which is to undo a prior authorization. And that creates a very unique circumstance in and of itself. But the greater question is, and I think something that we need to be very mindful of in this body is the precedence for our action in terms of transfers and leases. While it may be nearly inconsequential in this juncture because it's reversing a prior authorization, in the future, if we just include that kind of language, it could make any transfer or any lease take place. If we make it okay today, it could set the precedence for that becoming okay for any transfer or lease tomorrow that really should have an appraisal done, because it would be a transfer of property or a lease of property. So I think that it's important for us to go through the full exercise at this juncture and just come to terms with how exactly we want to handle these kind of transactions.
And so is it my understanding that the two of you are insistent that the Chamorro Land Trust pay for 2 appraisals in order to get land transferred to it?
My insistence, Mr. Speaker, is if the law is too restrictive for something like this to take place that really is inconsequential, then perhaps the law should be amended. But if we're going to, absent that, move this forward and establish a precedence in how to handle a transfer or a lease, I think that needs to be put on the table in its entirety
I
also.
think the more important question is the Chamorro Land Trust going to have to pay for appraisals for land that is going to be returned to it?
It will be returned to them in Bill 53, but it's also giving land back to the the municipality of Jigo in Bill 67. These are 2 companion bills that are separate because statute requires that you can only have one land transaction in any measure. But the reality is that these are both. This is returning to land trust from the municipality, and this is returning to the municipality from land trust. We're talking about 2 parcels that are going from one entity back to the other. The reversal of a prior authorization. And so that's why they're 2 separate bills. And so in the statute, the transferee is supposed to pay for the transferor. The transferee is supposed to pay for the appraisal. In this juncture, and this was brought up in our sideline discussion on the recess with the author, if we're going to be giving a parcel from one entity to another and from that same entity back to the other, reversing a previous swap, are both transferees going to have to pay for the appraisals of both properties, and to what purpose? So there is a conundrum in the statute because it does create a cost and a process that in a circumstance like this would be unnecessary. But the purpose of that statute was to protect not against these kind of conundrums, but against the transfer or lease of land without fully understanding the value. And so we do have a problem with existing law, I would argue being overly restrictive in something like this, but at the same time too, by making it less restrictive because of something like this, we may be establishing a precedence that would have greater ramifications in future transactions that are not as small of a deal as this is. If we allow for a simple notwithstanding provision to effectuate a transfer or a lease without an appraisal in this instance, then technically the same notwithstanding provision can effectuate a transfer or a lease in any future instance.
But that would also mean that in Bill 51, that transfer, whatever it is, administrative jurisdiction, whatever that means, needs an appraisal before Jigo can take the 5.5 acres.
Based on, when we were putting it through the Committee on Rules process, Mr. Speaker, Bill 52, the one that we just moved to 3rd reading, that did not transfer property. It was granting administrative jurisdiction, which, at least in the Committee on Rules process, and unless legal counsel...
And in this one, it's rescinding administrative jurisdiction. I was trying to figure out where the word administrative jurisdiction...
We see here
in all the years of my law school, there was no such thing as administrative jurisdiction. Thankfully, I saw that in 1994, whoever did the original Chamorro Land Trust and these transactions used the word administrative jurisdiction. We may have done nothing in 52. Because that may be the reason why for 24 years they've sat on this, because who knows what administrative jurisdiction means to be able to build or do anything with it.
I'm sorry, Mr. Speaker. I think part of the concern also would be in the title itself, where it says an active transfer lot. Perhaps it needs to be clarified to say an active transfer, the administrative jurisdiction.
No, it should read to rescind the administrative jurisdiction.
I'm talking about in the title on Bill 53.
Yes, it should read,
An act to transfer lot 7116121 municipality of Jigo.
it probably should read an act to rescind the administrative transfer from 1994.
Perhaps. Or both. But at this juncture, the motion on the floor is to put an outstanding provision in to authorize, with the intent of authorizing a transfer as is in the title. So perhaps we need to do a reconstruction of the measure, perhaps in its title. And also in its content, because if you read on line 7, it says transferred on page 1. It's just a lot of legal complications at this juncture, Mr. Speaker, and I would like to defer to legal counsel perhaps for the guidance. I'm just concerned about the precedence of the motion with respect to future measures that would not be jurisdiction based, but actual transfers and leases. So perhaps a request to have legal counsel provide us with additional guidance, and maybe we may need to it may require a substitution on the floor of these two measures to make it more adequately reflect that it's a jurisdictional issue and not an actual transfer of land. Mr. Speaker.
Senator Adam.
But the problem with that, if it is merely a rescindment of jurisdiction from the mayor, it's going to go back to the Department of Land Management. And what we want to do is we want to public law that created Chamorro Land Trust said that any public land that is not in the inventory, once we decide that we don't need it for what it was reserved for, it automatically goes to Chamorro Land Trust.
I understand. I think part of the problem is when your office wrote these two pieces and the other one, the use of a transfer of lots, because you then tied yourself up in this whole thing. If you're going to rescind or transfer administrative jurisdiction, you may get yourself around all three. All right? So,
But the problem, Mr. Speaker, is that if we just are to rescind the administrative jurisdiction, then the land then now comes under the control of Department of Land Management. We need to get it into the Chamorro Land Trust to resolve the issue of the people that are on the land. So just merely saying we rescind the jurisdiction from the mayor, all it's going to do is now land management becomes the new landlord or the landowner now. So that doesn't solve the problem, the fundamental problem that we're trying to resolve. We need to transfer it into the Chamorro Land Trust inventory, and that's why the language is written as it is. But I understand also the only other, I guess the other way to get around this is to put this thing on hold, introduce legislation that addresses this appraisal requirement until after enactment, that the appraisals shall be done after enactment so that we can get it through the legislative process. We can do that. That would be the technical way, I guess, but then what in effect are we going to do? This particular individual, land trust applicant, who, you know, he may just fall out of the eligibility realm for the veterans loan that he's on, that he has applied for. In fact, Guam Housing Corporation has been calling the office. Are we making any progress? Because if not, we're going to have to cancel that veterans loan application, which has already been approved, but cannot be consummated until, you know, we get these things resolved. So that's the impact of, you know, getting so wrapped around the axle that we lose it becomes almost, I don't know how to put it. We've lost the practical effect of what we want to do.
It's 4:30. I'm going to recess till 9 o'clock. The four of you remain in here with legal counsel and work this out before tomorrow morning. All right? All right.